Mr. Reyna, we had requested some judgments from past hearings he's had and held.
Right off the bat, the judge is not playing games. Not being dressed for trial? That's Courtroom 101, and Mr. Rhino just flunked it. Do you think his excuse holds up? Let me know in the comments.
And we were provided those today, one of them, and I had received already one. I discussed that with my client, and he kind of doesn't like the way I'm approaching everything, and doesn't like the way or he feels that I'm not representing him accurately.
Mr. Rayner, come on down.
So we might want to talk to him because he's asked me to get off the case. And I told him that's something you have to discuss with the judge. And for the record, we have been relayed an offer to my client.
All right. So, Mr. Rayner, are you Mr. Rayner?
Yes, miss.
All right. So it appears to the court that you do not want to come dressed for trial when you're supposed to be dressed for trial.
Well, believe it or not, Ms. Boyd, I wasn't aware of this trial in the first place. And
no, because here's the thing. Firstly, when a deputy at the jail tells you you're supposed to be dressed for trial, you're dressed for trial. And when your time, you were told before and you didn't do it. And guess what? If you ever come back to this court where a deputy at the jail has told you to dress for trial and you're not dressed, you know what's going to end up happening? You're going to be going to trial in that red jumpsuit. And you know why you're going to be going to trial in that red jumpsuit? Because it's going to have been your choice. I am not having you come back to this court.
That red jumpsuit warning? That's not just fashion advice. It signals danger to jurors. Judges use this as a wake-up call. Respect the process or it'll bite back hard in trial. Next.
Again, where you're pretending as though nobody told you you had a jury trial. The other thing, you're saying that your attorney is telling me that you want another attorney?
That's correct.
All right, then you need to hire one. Do you understand?
I don't have any support issues. Support at all as we speak right now at the moment.
What support for what?
It's ordinary to hire an attorney.
Oh, well, then this is your attorney. This is what I've discovered, and I've told many people this before. This is what ends up happening. When you, as a defense attorney, are placed to represent somebody and you've been appointed to represent them, number one, there are certain qualifications that you must have. This is a third-degree felony. It may be bumped up to a second-degree felony based upon what's in the indictment.
Legal insight. In many jurisdictions, defendants don't get to shop for public defenders. The judge is laying it out. This isn't a Netflix menu. If you want a new attorney, you better bring your own checkbook.
This attorney would not have been appointed to your case if he didn't have the qualifications to be on this case. I don't allow attorney shopping in this court. Whoever comes up on the wheel, that's who your attorney is. The state will tender an offer to your attorney because I require the state to tender an offer. State can make an offer and say, we're offering 20 years. The state can say they're offering the maximum. Guess what? Your attorney has absolutely, really no control over what the state is offering.
So what's
even if your attorney were to go to the state and say, well, these are the weaknesses in your case, and this is what my client is willing to accept, the state can still say, I am not going to offer your client what he wants. The only thing I will offer you is A, B, or C. And your attorney ethically is obligated to tender that offer to you. Now, you can accept it or not. That's completely up to you. There are certain rights you have when you're charged with the offense. One of them is whether or not you will accept an offer or not, and whether or not you will testify at trial, and what plea you will enter. Do you understand? So you're not getting another attorney. If you want to hire one, you are more than welcome to hire one. So this is your attorney. Next question.
Why does my case carry at least prison time and not probation?
Here's the thing. You will have to speak to your attorney. What I can tell you is There are certain cases, number one, that you're not eligible for probation. There are certain cases that if you go to a jury trial and if you are found guilty, you're not eligible for probation. There are some cases that if you go to jury trial, maybe you're eligible for probation from a court. But I cannot tell you whether or not, just based upon looking at your case, which would be the indictment for me, whether you're eligible or not. What I can tell you though, usually if you have a repeater count and you go to a jury trial, you're not eligible for probation. So you need to speak to your attorney about that. And I'm sure your attorney will tell you whether or not you're eligible. Think of criminal history this way. If you have somebody that you loan money to, right? Let's say somebody comes to you and they say, can you loan me $50 and I'll pay you back next week? And you say, yes, I will loan you the $50. What are you going to use it for? Oh, I got to pay my electric bill, which that would be a good electric bill these days. And that person gets the $50 and they don't pay you back. And you said you pay me back on this day. You're not paying me back. That person comes to you for a second time and said, look, I'm in dire straits. They're about to cut off my electric bill. I need $60. And you tell them, you know what? I gave you $50 just last week and you never paid it back. And they're like, I know, I'm so sorry for doing that, but I promise you this time I will pay it back and I really need the $60. So you loan them $60 and they don't pay it back. And then they come to you for a third time. You may say, I'm not going to loan you any money. I don't care what your problems is because I've loaned it to you 2 times before. And you.
That probation analogy with loaning money? Fire, it's powerful and brutally honest. The judge is basically saying, your second chances are running out. What do you think? Fair or too harsh?
You haven't paid it back. Sometimes people view criminal history that way. And when I was a prosecutor, sometimes people would view criminal history that way. They would say, you know what? I gave you probation before, you didn't do well on it, and you pick up another case. I gave you probation the second time, you didn't do well on it, and you pick up another case. So maybe that could be a reason why people make offers that they make. But what I want you to take away from this conversation is this attorney, according to the will, is qualified to handle the type of case that you're charged with. And I would tell you one of the qualifications they must have, and Mr. Gomez, correct me if I'm wrong, he has to have tried cases before, and he has to have tried felony cases before. You can't just have tried misdemeanor cases and then come to felony court and say, oh, I'm qualified. That's not how it works. So he's tried the necessary cases. And if you are upset by the offer that he is tendering to you, no, that is the offer that is the state has made. And in this court, I require everybody to treat each other with kindness. So I guarantee you, when the state made him that offer, the state wasn't mean. The state just says, this is the offer I'm making. And I expect you to treat your attorney with respect. I'm sure your attorney will treat you with respect. But again, if you want a different attorney, you need to retain an attorney. So that means you need to go out and hire an attorney. And if you don't have the money to hire an attorney, then this is your attorney. Do you understand? The other thing I want you, that's either yes or no.
Yes, miss.
The other thing I need you to understand, and again, we're not doing this anymore. If you are at the jail and they're ordering you dressed for court, that's me ordering you dressed for court because you're up for trial. And I will not have any qualms whatsoever with you going to trial dressed in that red uniform. And you and I both know that red uniform has several meanings attached to it, just the way the orange ones does and the blue ones does. The blue one for females, orange, just regular inmates. The red, gang member, age issue, in admin segregation. Yellow with stripes, pregnant, or just yellow, pregnant. Tan or grayish looking color, trustees. So if you want to come to trial dressed in red, that is completely up to you. Do you understand?
Yes, miss.
Do we understand each other?
Yes, miss.
Do you understand the offer that the state has made to you? That's either yes or no.
Yes.
Do you need to confer with your counsel anymore on the offer that the state has made to you. And if you would like to make a counter offer, I'm sure if you would tell your attorney, well, I want to accept this, but this is what I will accept. That's what's called a counter offer. But what that means is you're telling the state, I'm not accepting your offer. I will only accept this. So that means that you're rejecting the state's offer and it may or may not appear for you again. Do you understand?
Yes.
And I'm sure this attorney will be able to tell you what your range of punishment is in this type of case. I cannot tell you that because I don't know the facts of your case. The only thing I have before me is an indictment. You understand?
Yes.
Do you need to speak with your attorney some more? Do you need to see what evidence the state is saying they have?
No, miss.
Have you already seen that?
Not quite yet, but yes, I have.
Mr. Gomez, will you let him see that since we're all here?
I could confer with him again.
All right, so your attorney is going to confer with you and the state will let him see their file so you can see their file and see what they have, okay? All right, thank you. 2019 CR 11647, State of Texas versus Jamal Trayvon Coleman. Can I have parties announced for the record for the state?
Thanks, State of Texas.
Defense?
Monica Corolla for defense.
And are you Jamal Coleman?
Yes, ma'am.
Are you the same Jamal Coleman who was placed on deferred education in 2019 CR 11674 for the offense of aggravated assault with a deadly weapon on November 5th, 2020 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 2 on or about the 7th day of June 2023 in Bexar County, Texas. The defendant, Jamal Trayvon Coleman, the then and there failed to submit to a drug test in violation of condition number 2.
How do you plead to that? True or not true?
True. The state will waive and abandon the other allegations.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, fine you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there an agreement?
Yes, Your Honor. The agreement is, and should Your Honor choose to follow it, is to deny the motion and to alter and amend his conditions of probation to include the ISF dual track, and for him to complete the dual track and continue on probation.
All right, is that the agreement?
It is, Judge.
All right, Mr. Coleman, raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Jamal Trayvon Coleman.
All right, Mr. Coleman, do you want to go to prison?
I'm not enough.
Then why do you keep coming before me with violations?
I have an issue with drugs.
I mean, I know that, but I've sent you to different places and you're just not doing well. And so I don't know if I can help you or not. I don't know if you want the help. I can put people in whatever class that's available for you. If you have a drug problem, I can put you in a class for drug issues. But if you go there and you sit there, you internalize, but the first thing some problem comes before you, your answer is, oh, let me use drugs.
May I speak?
Yes.
I didn't get a chance to. I didn't really complete the first program, the safety that you put me in.
Mm-hmm.
I don't know if you remember, but I had a colostomy bag.
Yes, I do remember you.
So I got my colostomy bag removed,
Mm-hmm.
but I didn't stay at the Safe P facility. They took me to an infirmary unit, and so I've kind of missed the whole entire program. I think I was only in the program for about 2 months,
Mm-hmm.
if that. So I didn't really get a chance to be in the program.
So you had a colostomy bag, and again, you're using drugs.
Yes, ma'am.
That doesn't work well for anybody's health. And I will tell you, I have some friends who previously were addicted to drugs, and now they've been clean and sober for about 30 years. And they will all tell me, Stephanie, I can no longer abuse my body because I abused it so much. So guess what? They don't do ice cream. They don't do any of that. They're always working out, fruits, vegetables, their proteins. That's it, because they put their body through the ringer. And how old are you?
I'm 26.
You putting your body through the ringer. And I will tell you, meth not only affects the mental health part of it, but it affects your heart, it affects your liver, it affects everything else. You understand?
Yes, ma'am.
Probation. I'm sorry, do you have any gang affiliation?
I did when I was younger, not currently.
And what was that?
Blood.
He's saying that he's not a gang member anymore. I don't think felony drug court will accept him because I had put on here at one time, refer back to felony drug court, and they said no. Am I correct?
That is correct. I believe they will not accept him back.
And will ISF accept him with his gang affiliation?
This ending hits deep. She's not just sentencing, she's speaking from the heart. These courtroom moments aren't always about punishment. Sometimes, they're desperate attempts to save a life.
We'll have to do an evaluation.
All right. I'll deny the motion. Alter and amend conditions to include ISF, dual track. If he's not by ISF, then it's going to be safety.
Yes, ma'am.
Is there anything else you need from the court?
No, ma'am.
Am I going to see you back again here for this nonsense?
Got it. No, ma'am.
Do you have the tools you need to not use?
Yes, ma'am.
All right. Do you have a support system at home?
Yes, ma'am.
Who's your support system?
Grandmother, my mother, my father, my elderly grandparents.
All right. So you need to stop disappointing them because I'm sure each time you use, your mom's heart breaks, your grandparents' hearts break, your dad's heart probably breaks. You understand?
Yes, ma'am.
Nobody wants to, because you never know if the last time you use is the last time you use. Nobody wants to be called to have to identify your body because you're the person on the news who's on the street and they'll just say drug overdose and then they'll go on to the next person. You understand?
Yes, ma'am.
All right. Good luck to you.